again, Beyonce, she again, the title was a little bit misleading from the Daily Mail, where they're talking about she was able to win her 12-year legal battle for trademarking her daughter's Blue Ivy name, and it's a little bit misleading because she actually had the opportunity. I think when she originally filed for trademark protection in 2011, around that time frame, that USPTO actually granted her. They allowed her trademark. But again, when you file for trademark protection in the USPTO, you file a trademark application, they pick it up, they examine it, they're saying, okay, your trademark is allowed to be registered. We didn't find anything out there that was similar to your guys' trademark. You still have to complete the process. And what does that mean, Dave? That means you have to submit a specimen to the United States Patent and Trademark Office to kind of finalize things, to let them know that you're using a trademark, and then your trademark will issue into an actually registered trademark. And what Beyonce did, and I'm not going to read the article again, please feel free to go check out that kind of, I think the video ended up being 12 minutes on the channel where I'm kind of breaking in a deep dive, but this is more of a weekly recap where Beyonce never submitted that specimen, and as a result of that, her original trademark application was abandoned. So she actually was able to get trademark protection on the name Blue Ivy originally, and she didn't complete the process, so the application went abandoned. And that kind of goes maybe to a bigger point where I think she was saying, talking about, her and Jay Z was talking a long time about, hey, they just want to trademark the name Blue Ivy to keep others from being able to monetize off of it. And unfortunately, trademark law does not work like that. With a patent, you can get a patent and sit on it. With a copyright, you can get the copyright and sit on it. But with a trademark, you got to think these things last forever. So as a result of these things lasting forever, you have to actually be using them. They last forever, I should say, only to the extent that you're using a trademark. So I'm not sure if Beyonce and Jay Z's trademark attorney didn't consult them or kind of let them know what the real is, but you can't get a trademark and just sit on it. It seems like that's what they're trying to do. So when they initially got the mark allowed to complete the process for it to register into a trademark, they never did that. So the application went abandoned. Then what I think a couple years ago, 2023, around that time frame, they tried to resubmit a trademark application, which is totally fine, for the term Blue Ivy to trademark it. And what the USPTO, the examiner at the USPTO did this time is they cited, I should have had it's a clothing boutique out in Wisconsin, a lady who was running a clothing boutique called Blue Ivy, and she actually got that term registered with the trademark office. And now this time around, when Beyonce and Jay Z is trying to file for trademark protection for the term Blue Ivy, the examiner at the USPTO cites that Wisconsin clothing boutique against Jay Z's and Beyonce's trademark application, and a little bit of back and forth kind of pursued. And it seems like Beyonce and the team put forth arguments. Unfortunately, it seems like the Blue Ivy, the clothing boutique in Wisconsin that's named Blue Ivy, didn't kind of respond to Jay Z and Beyonce's arguments. And ultimately, this time around, the Carters was awarded, or again, the trademark application was allowed again out. She still has to complete the process. They still have to submit the specimen to complete the process and have the trademark application actually register into a trademark. So we'll see if they actually do that. But it seems like up until this point in time, their arguments that they put forth, they worked, and as a result of it, the application was allowed. Now, like I said, they still have to complete the process. And this brings up another good point. When you're filing for trademark protection, you actually are playing with fire when you file for trademark application, file for trademark protection, and then let the application go abandoned and then try to do it later on again. Now, in this case, it actually worked out for Beyonce and Jay Z because, the arguments kind of put forth, it seems like worked. But, sometimes you're not lucky, and you may have somebody else that once the application goes abandoned, somebody else is free to file for trademark protection for that term or that logo. And it may not work out for you the way it did for, again, Jay Z and Beyonce, as far as kind of the arguments persuading the examiner at the USPTO and the actual mark being awarded. So kind of definitely be conscious of that because, again, to the extent that the mark, the logo, the word, whatever it is that you're trying to get trademark is available, anybody can get trademark protection on it. And like I said, in Beyonce and Jay Z's case, they were allowed to register the mark. They didn't complete the process, 10, 12 years ago. And for whatever reason, a long gap was in the process. And then they recently refiled in 2023, where that clothing boutique in Wisconsin popped up, and they were able to get over that hump or get over it. And I actually got a good comment under the video that I did for that one. And please go check it out, where someone was saying, hey, so what happens to the clothing boutique in Wisconsin? Can she use the mark now? And the answer is simply yes. What the USPTO simply found was, hey, it's not a likelihood of confusion. That's the whole standard of trademark law. Is your mark, is somebody else's mark trying to register it in the future? Would it be a likelihood of confusion with your mark, your previously registered mark? And the examiner at the USPTO simply ruled is, hey, the mark Blue Ivy from Jay Z and Beyonce's application is not a likelihood of confusion with the Blue Ivy clothing boutique in Wisconsin. So both of them are allowed to use the mark for their respective purposes and kind of go from there.